California Civil Procedure Handbook rules, selected statutes and cases, and comparative analysis. Chapter 3, pleadings. In the complaint section, reading the notes and questions on the sufficiency of the complaint from Samol versus Sansui. Samol illustrates the two issues present in evaluating the sufficiency of a complaint, and by analogy, any pleading in the code pleading system. Since the complaint must obtain a statement of the facts constituting the cause of action, it must be both formally sufficient, the facts must be in the appropriate style of ultimate facts, and these facts must present each of the elements of one or more causes of action. In Samol, there was no question that the elements necessary to recover under the statute were clearly present. Plaintiff used the words of the statute, calculated and conscious willingness to permit injury or death in the complaint. Defendant objected that the allegation required more factual content than it should be disregarded as merely a conclusion of law. In federal court, pleading a fact-based cause of action is not necessary as long as the pleading gives the defendant fair notice of what the plaintiff's claim is and grounds upon which it rests, from Conley v. Gibson, which is federal. The complaint Samol does this, does it not? If so, why does the California code pleading system ask for more? Who gains and who loses in the code pleading system? Under traditional code pleading, the pleader can err by being either too general, using conclusions of law, or too specific, pleading evidence. See Caro and Company v. Security Pacific Business Credit, Inc. of 1990. A complaint must allege the ultimate facts necessary to a statement of an actionable claim. 3. Heightened pleading requirements. Causes of action based on fraud must be specifically pleaded. A general pleading of the legal conclusion of fraud is insufficient. Stanfield v. Starkley, 1990. Each of the elements of fraud, false representation of a material fact, knowledge of its falsity, intent to defraud, justifiable reliance, and resulting damage, must be alleged in full, factually and specifically. Nagy v. Nagy, California case, 1989. Complaint which lacked an allegation of a definite amount of damage held not to state a cause of action for fraud. Wilhelm v. Prey, Price, Williams and Russell, California, Appeal Court, 1986. Complaint which involves a complaint that failed to specifically plead factual basis for knowledge of falsity and justifiable reliance held not to state a fraud cause of action. Official form pleadings. The Judicial Council of California has developed and approved official form pleadings, complaints, cross-complaints, and answers for optional use for several basic of causes of action. CCP 425-12, the official form of the complaint for personal injury, property damage, wrongful death, motor vehicle cause of action is reproduced below. So, part 2 of this is part, it says subpart 2. So subpart 1 was code pleading. Subpart 2 is statement of damages in the complaint section of chapter 3. Code of Civil Procedure 425-10B provides that in superior court actions to recover actual or punitive damages for personal injury or wrongful death, the amount sought is not to be stated, apparently passed to avoid publicizing inflated claims against individuals and particularly healthcare providers. Section 425.10 must be read with Section 425.11 that gives a defending party the right at any time to request, quote, a statement setting forth the nature and amount of damages being sought, end quote. See also CCP 425.115, statement preserving right to seek punitive damages is the title of 425.115. Even if not demanded, the statement must be served before a default may be taken. Quoting Schwab vs. Rondell Holmes, Inc., California, 1991, stating default judgment invalid because plaintiff did not serve defendant a statement of damages. You've heard about that. So, I skipped 4 pages of judicial counsel forms, including the complaint for personal injury, property damage, and wrongful death, and a cause of action involving motor vehicle. I haven't seen that one before. And move on to the last paragraph of subpart 2 about the statement of damages. In some instances, the legislature imposes additional restrictions on the pleading of punitive damages claims. For example, CCP 425.13 bars inclusion of a punitive damages claim in a complaint seeking damages against a healthcare provider arising out of professional negligence unless the plaintiff first demonstrates to the court a substantial probability that the plaintiff will prevail on the claim. A plaintiff may not amend the complaint to include punitive damages claim unless the plaintiff first demonstrates by affidavits or declarations that she possesses a legally sufficient claim that is supported by competent admissible evidence. See College Hospital, Inc. v. Superior Court of 1994. Subpart 3 is titled Truth in Pleadings. This is a really long chapter. Let's just get through one more section. Section 128.5, Sanctions, and new Section 128.7. In 1981, the legislature passed Code of Civil Procedure, Section 128.5. This section authorizes trial courts to order the party's attorney, or both, to pay any reasonable expenses, including attorney fees, incurred by another party as a result of bad faith actions or tactics that are frivolous or solely intended to cause unnecessary delay. CCP Section 128.5a. Emphasis added. The section has had much less impact than the 1983 to 93 version of Federal Rule 11. To be considered frivolous, a bad faith act or tactic had to be A, totally and completely without merit, or B, for the sole purpose of harassing or opposing the party, an opposing party. Section 128.5b2. In addition, the California appellate courts have divided on the question of whether subjective bad faith is required in order to impose sanctions. Recent authority has been more supportive of a requirement that the action both lack any merit and have been brought for any improper purpose. See Levy v. Blum, California, 2001. Javer v. Stillinger, 1992. As a result of these limitations, in 1994, the legislature added a Section 128.7 to the Code of Civil Procedure. This section is patterned directly on Rule 11 of the FRCP. The section requires every pleading, petition, written notice of motion, or other similar paper shall be signed by at least one attorney of record in the attorney's individual name, or by a party not represented by an attorney. CCP 128.7a. The heart of the section 128.7b imposes on the attorney or party a series of certifications anytime the attorney or party makes a presentation to the court. B, quoting, by presenting to the court, whether by signing, filing, submitting, or later advocating a pleading, petition, written notice of motion, or similar paper, an attorney or unrepresented party is certifying that to the best of the person's knowledge, information, and belief, formed after a reasonable inquiry under the circumstances, all of the following conditions are met. 1. It is not being presented primarily for the improper purpose, such as to harass or to cause unnecessary delay or needless increase in the cost of litigation. 2. The claims, defenses, and other legal contentions therein are warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law or the establishment of new law. 3. The allegations and other factual contentions have evidentiary support, or if specifically so identified, are likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. 4. The denials of factual contentions are warranted on the evidence, or, if specifically so identified, are reasonably based on a lack of information or belief. Like the current version of Rule 11, sanctions are discretionary with the court, not mandatory upon finding a violation of one of the certifications. Also, like Rule 11, there is a safe harbor provision. A party served with a motion for CCP 128.7 sanctions ordinarily has 21 days in which to withdraw or correct the challenged paper before the motion is filed. Section 128.7c1. Sanctions are limited to what is sufficient to deter repetition of the conduct. Paying the injured party's attorney's fees as a sanction is limited to specific circumstances and when warranted for effective deterrence. Section 128.7d. Under 128.7d, sanctions may be made payable to the court. See Kane v. Hurley, California, 1994, and Levy v. Blum, California Appeals Court for thorough discussion of this issue, and CCP 128.5 and 128.7 generally, and Marriage of Schnabel, California, 1994, for a discussion of the imposition of sanctions pursuant to CCP 905 for a frivolous appeal. Voluntary dismissal to avoid Section 128.7 sanctions. The safe harbor provision of CCP 128.7c1 requires that the party seeking sanctions follow a two-step procedure. First, the party must serve a notice of motion for sanctions on the offending party at least 21 days before filing the motion with the court, which specifically describes the sanctionable conduct. Service of the motion on the offending party begins a 21-day safe harbor period during which a sanctions motion may not be filed with the court. If the pleading is withdrawn, the motion for sanctions may not be filed with the court. If the pleading is not withdrawn, the motion for sanctions may be filed. See Levy v. Blum again. If a plaintiff's complaint is dismissed during the 21-day safe harbor period, either voluntarily or involuntarily, the trial court no longer has the authority to award sanctions under 128.7c1. Hart v. Avtum from 2002, Malovec v. Hamrell, 1999, the Hart Court observed that allowing a party to serve and file a sanctions motion after the conclusion of the case would completely defeat the purpose of the safe harbor provision. How so? What is the purpose of the safe harbor provision? Does the trial court still have authority to award sanctions under 128.7c1, where the plaintiff has not withdrawn the offending complaint, but the trial court has sustained a demur to the complaint without leave to amend before the 21-day safe harbor period has passed? See Banks v. Hathaway, Parrott, Webster, Powers, and Chrisman in 2002, and involving an order sustaining a demur without leave to amend does not bar a motion for 128.7 sanctions unless the order is reduced to a judgment before the sanctions motion is served and filed. Does the plaintiff's voluntary dismissal of his action with prejudice after a defendant's motion for 128.7 sanction has been filed and taken under submission deprive the trial court of authority to grant the motion and impose sanctions on plaintiff for filing an improper complaint? See Eichenbaum v. Alone, 2003. The availability of 128.7 sanctions against an offending plaintiff who has voluntarily dismissed his action depends upon whether the sanctions motion was filed before or after dismissal. Subpart B, amendments. 1. California's Relation Back Doctrine. Barrington v. A.H. Robbins Co., Supreme Court of California, is a short case here heard by Justice Broussard. Plaintiff filed suit against her doctor, the manufacturer of Darvin and Doze 1 through 40, alleging medical malpractice and negligent failure to warn of the dangers involved in taking the drug. Plaintiff subsequently substituted A.H. Robbins Co. for one of the fictitious Doe defendants and filed an amended complaint alleging a new cause of action against Robbins. This new case alleged that the instrument causing her injury was a defective Dalkin Shield intrauterine manufactured by Robbins. The California Supreme Court concluded that the amended complaint did not relate back and discussed the relation back doctrine at length. We trace the evolution of the relation back doctrine to Smeltsley v. Nicholson Manufacturing Company in 1977 and formulated a general rule. An amended complaint relates back to the original complaint and thus avoids the statute of limitations as a bar against named parties substituted for fictitious defendants if it, 1, rests on the same general set of facts as the original complaint, and 2, refers to the same accident and same injuries as the original complaint. The contention that the Dawkins Shield cause of action does not relate back is supported by Coronet Manufacturing Co. v. Superior Court 1979. In Coronet, the original complaint in an action for wrongful death alleged that plaintiff's daughter was electrocuted while using dangerous instrumentality, a defective hair dryer. The defendants were the corporation manufactured the hair dryer and a number of dough component suppliers. The amended complaint, which identified Coronet for the first time as one of the dough component suppliers, was filed after the statute of limitation has run as to the original complaint. The amended complaint, however, alleged that the dangerous instrumentality was a lamp socket and switch manufactured by Coronet rather than the hair dryer. The court held that the amended complaint did not relate back to the original complaint and was thus barred by the statute of limitations. The court announced that an amended complaint relates back only if it is based on the same operative facts and refers to the same offending instrumentality and accident. The amended complaint before the court did not relate back because the difference between being electrocuted by a hairdryer and being electrocuted by a table lamp is as great as being electrocuted by a hairdryer and being poisoned by some improperly processed food found in the kitchen shelf. Although they relate to a single death at the single location, they are different accidents and involve different instrumentalities. Similarly, the new cause of action in the present case does not relate back because it, too, involves separate and distinct offending instrumentalities and accidents. The original complaint alleged that the offending instrumentality was Dr. Terrace's negligent medical treatment and the failure of Dr. Terrace and Darvon manufacturer to warn of the dangers involved in taking the prescription drug Darvon. The alleged accident was her ingestion of that drug. By contrast, the amended complaint alleged that the offending instrumentality was a defective and unsafe Dawkins Shield designed, manufactured, and sold by Robbins. The alleged accident was tubal ovarian abscesses and an infection resulting from her use of the Dawkins Shield. So the notes and questions regarding the relation back doctrine from this case in the final 3 paragraphs of this reading are: 1. As Barrington illustrates, the California courts typically state the current relation back doctrine is requiring that the amended complaint not only rest upon the same general set of facts, but also must involve the same accident and same injuries and refer to the same offending instrumentality as the original complaint. See Smeltsley v. Nicholson Manufacturing Company. Coronet Manufacturing Superior Court. For criticisms of these additional restrictions on the basic same general set of facts standard, see Walter W. Heiser, Relation Back and Amended Complaints. The California court should adopt a more pragmatic approach from Santa Clara Law Review, 2004. Professor Heiser explains why the use of the same accident, same injury, and same instrumentality tests as prerequisites to relation back is inconsistent with the modern view of civil litigation where discovery and pretrial orders, not pleadings, define the issues for trial. Heiser, Relation Back Supra. He argues that the same general set of facts standards should be applied in a pragmatic manner, which would focus on whether the defendant will be unfairly surprised and therefore unduly prejudiced by the amended complaint. The key inquiry is whether, during the course of pretrial discovery, the defendant was already made aware of and already has gathered facts responding to the new allegations in the amendment. Do you agree with these arguments? What problems do you see with such a pragmatic approach? And 2, Federal Rule 15c2 compared by requiring an amended complaint to refer to the same injury in addition to the same general set of facts. The California relation back is more restrictive than its federal counterpart under Rule 15c2 FRCP, which authorizes relation back in federal court when the amended complaint refers to the same conduct, transaction, or occurrence set forth in the original pleading. For example, assume in a car crash case that the plaintiff files a timely complaint against the defendant, other driver, seeking damages for property damage to her vehicle. After the statute of limitations has expired, the plaintiff files an amended complaint seeking personal injury damages caused by the same accident. The amended complaint would relate back to the original complaint under Federal Rule 15c2 because they both refer to the same occurrence, the car crash. But the amended complaint would not relate back under the California doctrine because it alleges a different injury than the original complaint. See Sidney v. Superior Court in 1988. So going to stop here, but subpart 2 under subpart B, amendments, is California's fictitious Doe defendant procedure, a case Stretcher versus Tommy's Electric Company. There will be notes after that case. And subpart C of chapter 3 is demurs, general and special demurs. D will be answers, and under answers there will be an introductory note and raising a new matter 1 and 2 before reaching chapter 4.